Afternoon, everybody. My name is Giacomo Delledonne. I'm Assistant Professor of Constitutional Law at Scuola Superiore Sant'Anna, and I'm one of the editors of the Sant'Anna Legal Studies paper archive, together with my colleague, Professor Giuseppe Martinico. Today, it's my great pleasure to moderate this webinar, which will focus on a recent and very interesting book, The Constitution of Italy, a Contextual Analysis by Marta Cartabia and Nicola Lupo. This book is part of a very well-known series published by Hart, Constitutional Systems of the World. The authors, which I wholeheartedly thank for joining us today, are Marta Cartabia, Professor of Constitutional Law at Bocconi University in Milan and formerly President of the Constitutional Court of Italy and Minister of Justice, and Nicola Lupo, Professor of Public Law at Guido Carli in Rome, currently coordinator of the unit for better regulation for the purposes of implementing the National Recovery and Resilience Plan. Thanks indeed for being here, and I would also like to thank our discussants, Professor Anna Gamper from the University of Innsbruck and Professor Jens Woelk from the University of Trento. The style of the house is based on the authors of the book speaking first, then the discussants will follow, and we will have some time for a questions and answers session. So, Professor Cartabia, the floor is yours.
So thank you so much. Thank you to Giacomo Delledonne and Giuseppe Martinico for convening this event and this discussion over this book on the Italian Constitution. I would like to thank of this possibility to start, in fact, my coming back to the academic life with this event, because after all, it's a long time that for a reason or another, I had to suspend a little bit my teaching and also my academic research. There is something, however, that I didn't want to put into brackets into this period where my main energies were devoted to institutional aims and charges. And it was and it is the idea of trying to work to some texts in order to spread the rich and original experience of the Italian constitutional system. Until a few years ago, the Italian constitution was not that much considered even in comparative studies for a number of reasons, but in my view, one of these reasons was to be attached to the lack or limited availability of sources readable in a common language, which is indeed English. This is not longer the case. There are nowadays a number of textbooks, treatises concerning the Italian constitution, but I also think that it's not easy to convey the proper meaning and the proper experience of the Italian constitutional and institutional life without an approach which is exactly the approach taken and requested by this series that is based on a contextual analysis. Just reading the norms, the text of the Constitution is a first step, but in my view, in order to properly understand any constitution, but indeed especially the Italian one, it is necessary to take into account First of all, history and in general the political system and the way the institution works in action, not only on the books. I think that we have something to say and to offer to the reflection of other experiences. And these original traits of the Italian Constitution, in my view, are to be retrieved in its historical roots. I assume that most of the people in the audience already are very well educated and they know about the Italian experience, but let me just summarize very quickly some points. The Italian Constitution is one of the constitutions which is a reply to the authoritarian regime and to totalitarian experience that affected almost all the countries in Europe between the two wars. It is, let's say, in order to use a common expression, or like Bruce Ackerman put it, a never again constitution, never again back to a sort of authoritarian systems, hyper-centralized state, lack of liberties, and all the things that authoritarian regime meant during the two world war in Europe. Second point, the Italian Constitution in a way was written by undecided winners, because it was clear who was defeated after the experience of totalitarianism. It was the fascist style, the fascist party, the fascist experience. But as to the other parties, political parties, the Christian Democrats, the Communist Party, the Socialist Party, the Liberals, the Republicans, they were all in a way winner, but they could not predict who would be in power after the first free election with the new constitution. So there were a number of subjects, of actors that were, contesting the scenario and trying to gain power in the new setting of the new republic. Third point, the constitution was written in a moving scenario at the international level. In the years when the Italian constitution was written, there was an undecided set of relations between the USSR and the USA in the international level. The Yalta Agreement did not yet set completely clear the setting of the international forces. And this was also very much relevant from the internal point of view, because two of the main political parties were in a way referring to two different international superpowers at the international level. So it was a very difficult context in which, and very challenging context to get to a shared result over the fundamental text of the new republic. So all the political actors knew very well that a reconstruction of the Italian state was mandatory. It was out of questions that a new constitution was necessary, and they all shared the necessity of a common goal. However, conflicts and ideological division between the different parties, and especially between the two main political groups, concerned every single aspect to be decided, and also the very fundamental orientation of the new state. By the way, it was not even clear whether Italy would become a republic or continue with the monarchy experience. That was a decision that was taken at the beginning of the Constituent Assembly by a referendum, but it was a major decision to be taken, and the result was a clear but not overwhelming winning of the Republic. I would say that the two blocs, the Christian Democrats and the Communist and Socialist Party, had opposite views on everything. Using the word that was very common in that time, they had opposite Weltanschauung, vision and of the world. And that was clear on every single point. For example, as to the economic framework of the new republic, free market versus state economy, public economy, democracy as giving all the power to the people and the parliament, or considering some limits to this power. There was a big discussion over the institution of the Constitutional Court, because for some of the political parties it was perceived as a limitation, undue limitation of the democracy and the sovereignty of the people. Centralized state that was supported mainly at the beginning in the discussion of the Constituent Assembly by the Communist Party versus local powers and regions. And indeed, the difficult issue in Italy on the relationship between state and church. We can go on. There were so many points to be decided in the Constitution that were a reason for conflicts for the main political actors of the time. I've just mentioned some of them. But what is interesting, in my view, and it was important to this purpose to recall this division, is the attitudes of the leaders of those political parties in front of these very divisive and conflictual issues. I would like to just to remind two small examples. One by one of the charismatic leaders of the Christian Democrats, and the other from the Communist Party. For example, Giorgio La Pira, it was a member of the Christian Democrats, at the very end of the work of the Constituent Assembly, proposed to introduce a preamble to the Constitution. And in this preamble, he proposed to add a sentence reading, "In the name of God, the Italian people decided," and so on and so forth. This idea of mentioning the word God, that is something that is pretty common in many constitutions, even in the German one that was written in almost the same time, was indeed in Italy inflamed a debate, because the religious issue was so a reason of concern and different views in the political parties. He proposed his views, but when it was clear that this proposal was putting at risk the whole work of the Constituent Assembly, he decided to withdraw the proposal. On the same issues and on the opposite front, Palmiro Togliatti, surprisingly enough, asked the Communist Party, the communist representative in the Constituent Assembly, to vote in favor of Article 7 and 8 of the Constitution, which were the two articles regulating the relationship between state and church, referring to the agreement, the Patti Lateranensi, which was something pretty much debatable because they were written under the fascist regime. So the party that was not in principle in favor of those agreements, nevertheless, for reasons of peace, social peace, that was the word that was used by Togliatti, proposed to cast the vote in favor also of this article. So these are just two small examples, but it is the general attitude that brought to a wonderful result, in my view, of the Italian Constitution, and brought to some original solution, even in comparison with the other constitutions. For example, different views on the principle of equality. For some of the most traditional parties, equality would just mean non-discrimination. On the opposite, equality for the most progressive parties would, on the contrary, means an improvement of the condition of the most vulnerable groups, brought to this wonderful result of Article 3 of the Constitution, which in the first paragraph replies all the traditional meanings of non-discrimination, formal equality, but on the second paragraph added a very contemporary provision, something that anticipated in a way the affirmative action or the reverse discrimination use of equality. So when in the 90s, the discussion about the affirmative action started in Italy as well as in many other parties in many other countries. In a way, the Italian constitution was ready to accept. There was no tension between affirmative action and positive action and the principle of equality, because it was already anticipated in the second paragraph of Article 3. The same can be said for individual rights, which are very much supported and guaranteed and strongly guaranteed in the Constitution, but not only as rights of individuals, but also of taking into consideration groups, communities, associations, NGOs, because of this convergence of different vision between the liberals and the more traditional political parties, the Christian Democrats and the communists. So we can go on and we can give a number of different examples of this, let's say, fruitful cross-fertilization between opposite vision of the words that, in my view, give the Italian constitution the character of a sort of evergreen constitution. Here, I don't want to say that it is not necessary from time to time to revise one provision or another. And we know very well that in this moment in Italy, there is an open debate about possibility of reform of the institutional, especially the institutional part of the Constitution, those concerning the political bodies, government, parliament, and the system of government as such. And in fact, a number of revision has taken place. The last one was last year, adding the word environment in the text of the Constitution, which was already in a way anticipated in a previous reform of 2001, but it was in the new reform, it is considered as a goal, one of the fundamental principles to be protected by the actors of the Republic. What happened, however, is that so far, let's say, insular and detailed revision has been successful. So far, on the contrary, all the attempt to put in place a revision of the overall political architecture did not come to a positive outcome so far. However, the discussion comes every now and then, because it is true that one of the characteristic of the Italian constitution that was, as I mentioned at the beginning, written with the idea of avoiding the risk to reply a totalitarian experience, the result is that the structure of the political institution has put in place a pretty weak political system, and the number of government that over time have succeeded are 68, if I'm not mistaken, 68 cabinets in 75 years, is the major problem that every discussion about the reform of the Constitution wanted to address, and also is in the focus of the nowadays discussion. I think that I can stop here, and indeed I will be ready to answer any question that will come from the discussant or from the audience. And thank you for paying attention to our presentation. Thank you so much.
Thanks indeed for your intervention and also for being concise. Now it's for Nicola Lupo.
Let me start by thanking very warmly Giuseppe Martinico and Giacomo Delledonne for organizing this discussion. I like a lot the idea the STARS is pursuing very well of launching almost all new books, constitutional law, that have been published, and I think it's fully in line with the mentorship and the legacy of Professor Alessandro Pizzorusso. I want to remember, because I think we have the importance of books in his culture, and there's also something that I think everyone among us brings with himself. I also want to thank an Israeli colleague, Itai Bar Simontov, for allowing me to join this meeting from Tel Aviv and giving me room for taking part to it. I think it's a small sign of an international community of constitutional law scholars that is developing in an impressive way, especially in the last 2 decades, I would say. And I think that both the book we are discussing today and the event holding now are an expression of this international community of constitutional lawyers that is spreading and increasing. And so I'm very much looking forward to receiving some feedback and comments by the two discussants, Professor Anna Gamper and Professor Jens Woelk. Both of them I know superficially, and I think there will be a wonderful opportunity for knowing them, both of them better, and also collecting the criticism and the suggestions regarding the book. So really, a real book discussion as the ones there should be. Marta said, of course, everything much better than I could, so I'm not adding much on the content and the philosophy of the book. Maybe I can just add something regarding, let's say, some background or some back office even of the production of the book, which might be of some interest, also as an excuse for some limits that can be found for sure on it. Let me just state that it's been a long gestation, long process to write this book. I think the contract was signed 7 years from the publication, from the actual publication of the book. This means that there are a couple of years before in which we started reasoning about the book and the structure and the content of the book. Of course, it's been it's been important to fill the gap in the series of the constitutional system of the world, because the Italian system was missing, and it was a big shame because the series was even conceived in Italy. The first book on the constitution of the UK was written first in Italian, then into English, if I'm not mistaken, by Peter Leyland, who was a big part of the founding and coordinating the book series. The process has been long, has been a joint work with Marta, that's been a huge pleasure, and also a teamwork, because the revision of the text took some place, and also the series editors were very active in reading the structure of the book, but also the actual content of it. And from this process, I really learned a lot, and I think I increased my capacity and scholarship on this, as well as in a parallel process, as I teaching public law in a first-year course to political science students in a PP bachelor at Lewis. I started teaching this course in 2012. So it's something that went along the process of writing the book, of co-writing the book with Marta. Of course, the time that has passed means also that it's been very difficult, especially in a constitutional system, very dynamic and uncertain, like the Italian one, to find one idea that could lead the whole process. One single idea you can identify. The editors asked us, the series, to find a main idea, and of course the system was changed so fast, so quickly, that it was difficult to find something that was fully convincing. And I think that Marta just identified very well what was the idea we have, and up to a certain extent to do some performance check of the Italian Constitution. After 75 years from its entry to force, celebrated just the 1st of January, I think it's important to give a contextual analysis in an historical perspective that tries to summarize what the Constitution is doing and what has done, of course. Our approach was not manualistic, nor comprehensive, but we wanted to be contextual and selective. So it's not a handbook, it's not a textbook, but it's a, let's say, sort of guide for those who want to better understand the functioning of the Italian Constitution and the actual performance of it. We've had to adhere with the rather strict editorial characteristics of the series. For instance, the change to the chapter structure were minimal and strongly discussed with the series editors. So there are some slight changes, but the general structure of the book is the one of the series. This explains why some chapters that normally appear in textbooks of Italian constitutional law are not present. The state, for instance, the sources of law. We don't have these chapters because these chapters are not present in the overall structure of the series. While we insisted a lot to have some chapters, the one that places the Italian Constitution within the composite European Constitution, for instance, since the beginning, and also the importance of the order of chapters was discussed, and also this, the idea of placing the protection of rights at the end of the book has been also rather important in my view. Finally, the readership, I would say, and then I'm going to conclude and to leave the floor to the two discussants. The readership is mainly non-Italian because of the series, because of the publisher. So there was a decision also regarding the language. Should it be the UK English? Should it be the US English? Should it be international English? If it exists, of course. And this implies also choices regarding the way to the translation of many legal terminology, Italian legal terminology that has been proposed in the book. We normally also tend to remember also the Italian wording in order to help students and to encourage them also to use the text of the Constitution together with the book, which I think is always an important suggestion for law students in general. And the market for the book, it was a bit strange for the series decided out of the blue to publish also the hardback edition before the paperback edition. This implied that the price of the book was a bit crazy at the beginning, but luckily after 6 months we are now able to get the paperback version at a price that is accessible, I think, to students or to the general public who is interested in understanding the Italian system. Maybe one last word I would devote to the cover of the book, if it's possible, which is consistently with the series designed and painted. Is an original painting by Long Leyland, and it takes inspiration from several discussions and we had together with Marta and the artist. And you will find in the beginning of the book a pictorial narrative that explains rather well the reasons that are the basis of course, they're freely chosen by the artist, but after some discussion with the authors in order to be consistent with what is the content, the actual content of the book. I don't think if I have much else to add, apart from really going to listen and possibly to reply to the comments and questions that will be raised. Thanks a lot.
Thank you, Nicola. Thanks to both of you for making it possible for all of us to get an idea, get a sense of the spirit, the guiding ideas of this book. Now it's for our discussants to take the floor. The first of them is Professor Anna Gamper. So thank you for joining us. Our idea was to involve some scholars who are familiar with the Italian system, but with a different background, in order to make comments and raise points on this book. So the floor is yours.
Thank you very much. Buonasera from Innsbruck. It's really a great honor and privilege to attend this webinar today. Thank you very much for inviting me. And first of all, congratulations on a really splendid book. I'm now speaking from the perspective of a foreign scholar of constitutional law, but the book truly gives a wonderfully clear and concise insight into the Italian constitution. And it has already been pointed out that it also delves into topics which are not simply Italian, but which are also internationally discussed, also in Austria. I was surprised at finding how many similar or even the same topics are discussed in my own country, but also on a more international level. So it was quite difficult to choose among so many interesting issues on which topics I'd like to make some comments. And I spoke to Jens Woelk formally, and we decided not to choose perhaps the same issues, but different ones. And I chose 3 different issues. And the first of this first issue refers to the issue of constitutional unamendability and constitutional principles. Both authors point out that, and that's of course a fact, that after the Second World War, a number of constitutions entrenched explicit unamendability clauses. I think nowadays about 1/3 of the constitutions across the globe contain such an explicit clause of unamendability. And we do know, of course, that Article 139 of the Italian Constitution protects the form of the Republic from amendment. And the book points out that in 1988, the Italian Constitutional Court began its standing case law, according to which even the principles mentioned at the beginning of the Italian Constitution also implicitly belong to a nucleus of unamendability of the Italian Constitution, which I found very interesting indeed, because of course you could say, well, if you have an explicit unamendability clause, why did the constitutional lawmaker not include any other explicit principles as well, if the constitutional lawmaker wanted to involve them? On the one hand, on the other hand, you could say, well, it's the form of the Republic that is protected. And it's a question of interpretation what Republic means. Is it just not having a monarchy? Or do we have some qualities, legal qualities attached to republicanism, which are mentioned at the beginning of the Italian Constitution, such as, for example, a democratic republic, a unitary, even though regionalized republic, and so on. So perhaps that's an issue for interpretation. But what I found interesting is that obviously, according to that case law, the Italian Constitution seems to be a hybrid between having an explicit eternity clause on the one hand and what we call the basic structure doctrine on the other hand. So when we think of the origins of the basic structure doctrine, which of course is rooted in older French and German theory, but the first case was the Kesavananda case in India. So here we had a constitution lacking an explicit unamendability clause. It was just an implicit understanding of the constitution to find out that there is an implicit basic structure. But here, obviously, we do have an explicit clause, but still these principles are implicitly added in a sense to that clause, or are involved into that clause by a certain kind of interpretation. I found it interesting also to compare this a little bit to the Austrian Constitutional Court's case law, in the sense that the Italian Constitutional Court held that one must not modify the essential content of these principles. And this reminded me a little bit of the Austrian Constitutional Court's case law on leading constitutional principles of the Austrian Constitution, which, according to the court, are not unamendable. But if you want to amend them seriously, you need to use a qualified amendment procedure and not the ordinary constitutional amendment procedure. And also the Austrian court emphasized the essential content of these leading principles must not be seriously amended unless the qualified amendment procedure takes place. And of course, there was much discussion. I'm wondering what the case is here in Italy. What does essential content of a principle mean? So I think there is a rather wide discretion of constitutional courts on that question, because if a principle is entrenched in the constitution, it's good, but normally this is made in a rather vague way. And to say what is the essential content, so it's an important question, of course, but there is also a wide discretion, I think, on that. Well, a second point I'd like to make is on a judgment, which is called the probably most relevant decision on the issue of regionalism by the authors of the book. It's a judgment taken in 2007 on Sardinia, on the question whether the term sovereign or sovereignty may be used by a region. Of course, we do know the context of that judgment. I wouldn't like to elaborate very much on the sovereignty question, even though, of course, one could compare this very well to, let's say, terminology like self-determination in the Catalonian context and so on. But I would like to elaborate a little bit on 2 or 3 sentences, which are also quoted in the book, on which, interestingly, the Italian Constitutional Court, well, theoretically examined what federalism obviously is. The Italian Constitutional Court said that normally a federal system was founded by previously sovereign units that together by a compact normally founded the federal system, and they had been sovereign previously, and this was not the case in Italy, of course not. Yeah. But what I think interesting, I think it's almost refreshing to read that coming from a constitutional court, because I compare this to recent opinions given on the foundation of federalism in the literature. I think it has been for at least 2 decades or so that the international literature on federalism also admits other ways of founding a federal system, not just by the US model, obviously alluded to by the Italian Constitutional Court in that judgment, namely by having independent units that together make a compact, and then they found originally the federal state. But of course there are also other ways of founding a federal state, namely by transforming an originally unitary constitution through constitutional amendments. And of course examples like Belgium, but even to some extent Italy or Spain, have been discussed as having become either a federal or quasi-federal state in that way. I think as regards Italy, the discussion now has become a little bit, well, how to say, decreased a little bit. So it seems that today Italian academics rather say, well, it's a regional kind of state, it's a sui generis kind of regionalized state, rather than saying quasi-federal. I think that's right. But still, I think we can agree on that in constitutional terms, when we find that a federal constitution contains certain elements that we can describe as being essential for a federal state, then it may be called a federal constitution. Of course, there's much discussion on what these elements are. But now I'm referring to a more recent kind of literature, which goes much beyond the extension of founding a federal state after the originally unitary constitution. And here I allude very much to a book recently published by Stephen Tierney. It's called The Federal Contract. And here it seems that federalism, according to the US model, is literally called a distorting way of making federalism, federal systems in that book, which is really interesting to read, are more or less conceived as being, well, systems which have a pluralist society. And federalism is a kind of pluralism principle in which certain groups are represented in different ways. So I'm not quite sure whether this, let's say, deconstruction of what federalism means is a helpful category, because then of course we can count many, many different systems as federal, but this is not a very precise category. We should not hide our view from being perhaps a bit more precise about different ways of constitutionalizing federalism into different categories, and also distinguish between different ways of founding such a system. In that sense, I think the statement made by the Italian Constitutional Court was quite refreshing, I think, when compared to this new tendency also in the academic literature. Lastly, let me say a few points about the Italian Constitutional Court. I found this chapter particularly interesting in the book. It very kindly, the authors refer to the Austrian or Kelsenian model of a specialized constitutional court. We do know about the prototype of such a court, which came into force in Austria in 1920. And the authors, interestingly, mention they call it a hybrid system in Italy, where ordinary courts play a certain role also in the procedure of constitutional review, because they submit questions to the Constitutional Court. In that sense, I think the Austrian model entrenches quite the same. This is not a hybrid between, I think, the American and Austrian model, but even in 1920, the Austrian federal constitution provided that possibility, and of course nowadays again. So the ordinary courts, all courts in Austria, have to refer constitutional questions to the Constitutional Court, even though, of course, other qualities attached to either the Austrian or American model are missing in one way or the other with regard to the Austrian model. And the Italian model is, of course, not just a mirror image of the Austrian model, that's clear, of course, but there are some interesting similarities I found out. For example, the use of the method of interpreting a statute as being consistent with the Constitution. It's a kind of method frequently used by constitutional courts and also by the Austrian Constitutional Court. In Austria, we have had much literature and quite a controversy over the question of whether our court uses that method a little too much, because normally it should use that method only in case of doubt, after having exhausted all other classical interpretation methods. Then the court could resort to saying, well, in doubt, I interpret that statute in accordance with the Constitution. But the big difference between Italy and Austria, it seems to me, after having read this in the book, is that in Italy, the Italian Constitutional Court even invites the lower courts to use that method in order for these courts not to submit the question to the Constitutional Court, but to use the method themselves. And here, I should say, the Austrian Constitutional Court is much more jealous of its, let's call it, monopoly of constitutional review. In Austria, the Constitutional Court has sometimes even criticized other courts for not submitting a doubtful statute to the Constitutional Court, but using the consistency method themselves. But the Austrian court said, well, you should not use that method. If you have doubts about the constitutionality of a statute, please submit it to the Constitutional Court, but do not yourself use that method. So there seems to be a bit of difference here. Again, a similarity is the absence of a separate vote. I found it very interesting. It's quoted in the book that the Italian Constitutional Court obviously argues that the court wants to give a uniform statement. Judges sit in the plenary, they are included in one way or another in formulating a decision. And quite in the same words, the Austrian Constitutional Court said 1.5 years ago or so, on an envisaged draft law which would have introduced a separate vote in Austria, that the Constitutional Court would not like such a separate vote because the judges are included, even if they are in the minority, the court should speak with one voice, and so on. So in Austria, the draft was put on ice, but it was interesting to find that the draft was made 1.5 years ago. Lastly, let me say something about the issue of positive lawmaking, because this is also mentioned in the book. And of course, the terminology to differentiate between a negative and positive lawmaking also goes back to Hans Kelsen, who said that the Austrian Constitutional Court was just a negative lawmaker. And we do know nowadays that even such courts, even the Austrian court, is not just a negative lawmaker, but indirectly, constitutional courts also have some kinds of positive lawmaking powers. Let me just mention one example. When the Austrian court repeals part of a statute, some of the text remains, which is not unconstitutional, but of course it adopts another meaning because part that was repealed is missing. This is also a kind of positive lawmaking exactly through negative lawmaking, through repealing part of a statute. However, it seems to me, after having read your chapter in the book, that the Italian Constitutional Court has more powers in this regard. For example, euthanasia case, for example, having the possibility to admonish the lawmaker, saying if you won't alter the current law, then we are forced to do something about it by declaring it perhaps unconstitutional in a year or so. I found this a very interesting power in Italy. So I think I should stop here, but not without congratulating you once more on that excellent book, and for saying that I have always been strongly impressed by the activities and engagements of my dear Italian colleagues in the field of comparative constitutional law. So my impression has been for quite a long while that the Italian constitution already belongs to the better known constitutions of the world. But I'm sure that this book, also because of the outstanding authors, will contribute to that fact very much. And thank you again for inviting me.
Thank you, Anna. Thank you for your words, and also for mentioning the judgment of the court in 2007 of the sovereignty of Sardinia, in which one of our mentors, the late Paolo Carrozza, was pleading the case on behalf of the regional government of Sardinia. Now it's for Jens Woelk to give his comment. Thank you, Jens.
Thank you very much. Thank you for the authors in writing such a great book. I have to say I'm also biased, and my take would be if some decades ago such a book would have been available, I would have been much favored in understanding the Italian system, and I think if this is the purpose of the book, and it seems that this is the purpose of the book, so Nicola Lupo said it's supposed to be a guide, and if you look at the back of the cover, you can see it's an introduction, but it shall also favor deeper understanding, which maybe could also be a kind of contradiction, but in a way, I think this book actually manages to combine both the overview with, as also Anna Gamper has already said, referring to some examples, going into depth with regard to some issues, some selected issues, of course. But I think this is a very, very useful book for people who want to know more about the Italian system, even about specific issues of the Italian system in context, because I think this is the other great advantage of this book, as has already been said by the authors. And if it would not have been said, apart from the subtitle, it would be very clear, because it's very clearly coming out of the whole book that there's always context to consider. There's always context to consider, because I promised myself not to say it, but now I will say it, because Marta Cartabia has talked about the evergreen constitution, and so this is too provoking for me for not referring to Roberto Benigni and La più bella del mondo, La Costituzione più bella del mondo, which is of course an exaggeration, but it also shows maybe a kind of emotional attachment to this text. But this is the text, but then there's reality, and I think these two, the constitutional reality, and this is a huge advantage of this book, comes very clearly out, the evolutionary aspect. And I'd say, I'd like to mention, as Nicola Lupo has already done, but it is always the problem when you talk last, the cover of the book. I don't know whether you have this here, because I think this is very interesting also to read the interpretation. Of course, you can do it yourself, but then you can also have a guide by by non Leyland, exactly. So there's the shadow of the past, the fascist regime, and the answer this constitution is to this fascist regime. Then there are these Escher-style stairways, which symbolize the vertical and horizontal separation of powers. From my point of view, you could also add, and I will refer to this in a moment, where do these lead to? Well, there's no clear direction in a way, if I may say so in a slightly respectful but teasing way. Then at the center, and we can maybe also, perhaps with Marta Cartabia, discuss, is it really at the center? There is a female figure, which is quite surprising. No? But maybe it's the surprise that finally in 1946, women were more prominently involved and finally had equal rights in political participation, although in the Constituent Assembly there were only 21 of them out of 556 members. Then the group of politicians from the main parties, again here we all have male figures, compromise and consensus, as has been said, in front of Dante, symbolizing, maybe if as a German I might add, the dream of a united Italian nation, of unity. And then again, the same dream, the umbrella with the tricolors and the Italian flag, national community and unity are symbolized. So I don't want to exaggerate, but if you then turn the book and look at the cover, at the back, then you can see there are three main functions of the constitutions which are invoked. The first is maintaining a community. The second one, protecting fundamental rights of citizens. And the third one, ensuring the separation of powers. And I briefly want to touch upon these, but to me, it seems the main concern of the book, but also of the Constitution itself, is to maintain and maybe even to create a community. Maybe I'm a bit exaggerating, but I was also quite struck by the emphasis given in the first chapter and also now in your presentations to the aspect of transition, the transitional function of the Constitution from, or better, the transformative function of the Constitution, turning Italy into a modern constitutional democracy, the Never Again Constitution. But it's also mentioned, and I think this is very useful, that all four codes enacted during the fascist regime remained in force throughout the first 40 years. So the sub-constitutional legal framework was still characterized strongly by fascist culture and only gradually brought in line. And the book tells this very openly, very clearly. Then it gives a judgment at the very beginning. It was successful because of, I quote, inclusive, dialogical, and incremental approach to constitutional change. Again, in Germany, we have a similar problem with democratic legitimacy at the beginning, an even worse problem in a way. But here, there was an initial referendum and then election of representatives, but the text of the Constitution was never put to a referendum, actually. And also this is clearly said at the beginning. And here Marta Cartabia has already, with the term undecided winners, characterized the fact that there was a coming together of different ideas, a merger of Catholic, Marxist, and liberal ideologies, but looking towards the past, trying to build something which was different from the past. But there was no shared vision of the future. And I think this is what explains the overall importance of balances, which to me seems a kind of red thread through most of the chapters. So to guarantee safeguards, balances everywhere, because there is no clear consensus on where to go together. And this might be, and this would be already a question also to the two authors, this might be a slightly different approach compared to many other constitutions, and might, of course, explains also the instability we have seen, because there was always the need to preserve the initial compromise. Anna Gamper has talked about the constitutional techniques already, but also the consequences for the implementation with all the delays. Here, I would also like to ask the authors an explanation. What is the difference between delays and an incremental approach? Probably that incremental would suggest that it had been planned, and probably many delays in the Italian constitution weren't planned from the very beginning. And also, which is I think also very important, very typical of the Italian situation, and not so frequent maybe the continuous debate on constitutional reform. Again, because it's more about the balances, it's more about also maybe keeping the academic and political community busy rather than really wanting to change things, because this would imply a clear position, taking a clear position, and this in again context, this in different historical periods has always been very difficult for Italy, for internal reasons, but also for being placed within the larger European picture. And here I'm coming to the structure. I was a bit now disappointed when you said that because I should have looked more intensely also to the other books of the series, which I know, but I didn't have this in my mind clearly, because I find very lucky that there is the second chapter at the very beginning of the book, so or close to the beginning, the chapter on the constitution in context regarding the composite European constitution, Italy as an EU member state, but also counter limits, the European Court of the Convention on Human Rights. I think this is a very modern approach, and I was a bit disappointed also to find the protection of rights at the very end of the book. On the other hand, you can say then you cannot overlook it. It's like a conclusion. So this would be my suggestion for an answer, but I'm very curious what would you say, apart from the constraints being, of course, in a way forced or at least politely invited to respect the order of the chapters, like in the other books of the series. But I think just to say one chapter which I'm missing is a chapter on fundamental principles. This would be or a part where these fundamental principles are a bit more pronounced. They are prominently discussed. They are, of course, to be found in the single chapters. But for example, minority protection is very, very briefly mentioned only as a kind of justification for the special autonomy of the Alpine regions, and in the part on regionalism, and though it is a fundamental principle of the Republic, and the same might be true for the relationship state-Catholic Church, but probably this is a matter of selection, and this would be, and for me, of course, it's a matter of perspective sitting in Trento and Bolzano. It's something which I, of course, jump on immediately. Then very few words, because it has been already to some extent addressed, on the form of government, forma di governo, and instability, because this is, of course, a mystery for many people who are not so familiar with the details of Italy and the Italian system. I think this is very well explained, and also before there was reference to the 68 governments. It's, of course, to be explained with a lack of this shared or common vision, and then in the different periods, I think also this categorization of the three main periods. And what I very much appreciate is the link to the role of the political parties. I think this kind of compromise, strong political parties and weak institutions, as it is said somewhere, and the changes of the electoral system, the radical transformation of the party system. So this is all very well explained, and I think this is very important for someone who wants to understand Italy. And here I think it's another compliment that the book is covering 70 years, and things have strongly changed over time, also the logic, but this is, I think, very well explained. Regionalism. Some words about regionalism, and I try not to repeat what or to overlap with Anna Gamper, because we have actually had a phone call before. Although the question here is always the riddle, the mystery: is the regional state a separate category, no, in between the unitary state and the federal state? Anna has already said something. I think it's still a bit of a paradox, though, and a contradiction, maybe even, that the regions on one hand are not considered sovereign bodies and cannot be considered sovereign bodies. On the other hand, they have political autonomy, or at least this is the ambition, no, to have. Do they have political autonomy? So we can also ask this way, and which regions, because maybe here it could have been a bit stronger. The distinction between, the distinction is there, of course, but a bit stronger, the distinction between this, within this asymmetrical design, that you have special and ordinary regions. Now the discussions on the enhanced autonomy. Again, you very well describe the evolution of the regional system, starting from the delayed implementation, the devolution of powers from state to regions, the regional emancipation also through the Constitutional Court. I remember very well 20 years ago when everybody was talking about a kind of federalization of Italy with a reform of the fifth title. And then the disappointing, for those who believe in regionalism, recentralization through the case law of the Constitutional Court. And there's a nice remark on the real life of the regional system, which I very much appreciated again, and the centripetal game. And now perhaps further differentiation. What is missing here from my point of view, but maybe this is already, probably this is already going beyond the purpose of the book, is the question of to me, there is a lack of a clear idea of a territorial structure. So what is this territorial structure for? Why do we have this? Is this, again, only a game in the general idea and general game of balances at different levels? So these are the Escher-style staircases on the cover, which do not lead in a clear direction. Or is there something more behind? It looks like more like a pendulum, that in the historical periods you have once more federalization or something, always in quotation marks, of course, and sometimes you have more re-centralization. Okay, I skip the other things. The participation deficit, of course, is all there. Then I think what's in order to come to the end, I just want to draw on the chapter of fundamental rights. So, like Anna did for the Constitutional Court, I think again here you could say from text to reality. This is a chapter which starts with a text, puts the text in context, again, also in the European context, with regard to the European instruments, but also with regard to the evolutive interpretation by the Constitutional Court, the Constitution as a living instrument. This is demonstrated with the example of the right to life very instructively. The dynamic interpretation and always the European influences. Again, I also very much like the part on the affirmative action or formal and substantive equality, which I think is very important. But there's also a more technical part on the limitation. And again, there are useful examples which are taken from real cases. And this goes really in some kind of technical depth already, which is very useful, I think, for the, in particular, non-Italian language reader in order to understand the Italian approach much better. And then there are, of course, also other examples on key rights and also on the question of the fundamental role. This has already been touched upon also by Anna, of the judiciary in cooperation with the Constitutional Court, which in particular for me, for example, as a reader with a German background, being used to the direct complaint to the Constitutional Court is very useful in order to get the feeling of how this is organized within Italy. I would like to talk, but I think I'm running already out of time. I would like to talk also on the chapter on the judiciary, which I found also very interesting, and the High Council of the Judiciary in particular. But I'd like to come to the end and say, for me, the book, and I think I have not said this expressly, is also very much appreciated because it's very reader-friendly. It's reader-friendly in language. It's not simple, but it's very well explained in a clear language, and it has focus. And I think these are very important qualities for a book which wants to combine introductory character with creating deeper understanding. Also the technique of an overview at the beginning of each chapter, what is to be expected by the chapter, and the conclusion at the end. The focus on fundamental question, I think these are qualities, and Anna has already said so, and I join her in this. There are always everywhere useful comparative references, very, very strongly to the European Union and to the European Convention on Human Rights levels, but also to other countries. And I think this is in line also with the relatively recent tendency or activity of the Italian Constitutional Court to publish selected judgments also in English language in order to make them better known. And last but not least, the book is up to date because it has just come out. And so it's also containing very recent information. So I could simply close, instead of saying thank you for writing this book, what do you want more? Thank you.
Very well, thank you, Jens. And so many points, many interesting points have been raised. Now we have some time for discussion. So those of you who are interested in asking questions, making points, etc., please raise your hands with the symbol down in the WebEx page, or you may also write it in the chat. Giuseppe Martinico.
Okay, so thanks indeed. I really enjoyed the discussion. Thanks so much for joining us. It is a great gift. And I would like to say a couple of things about the book, which I really enjoyed, especially as also Jens said, especially chapter 2, which emphasizes constitutional openness as one of the pillars of our constitutional experience. I think it is a crucial point that is sometimes on purpose omitted by the supporters of legal sovereignism. So it is important to, stress this point. I have three provocative questions. The first one is more, I would say, terminological / methodological. Nicola already said something about that, but I would like to explore the thing. What have been the biggest challenges from a terminological point of view that you have encountered in this book in order to make our constitutional experience understandable to comparative law scholars beyond Italy? So I don't know if you have some anecdotes concerning the choice of particular words that you have chosen after and the debate. In order that you make, our constitutional experience understandable from a comparative point of view. And the second and the third questions instead are more related to the contents, so to say. The first question is the following. The pandemic has led many constitutional law scholars to rediscover the distinction between emergency and exceptions, and exceptional Schmidt, and has led many to rediscover also the debate about the role of emergency clauses in comparative constitutional law. In this sense, Italy is a somewhat special case. In comparative law, as also the reports and the opinions of the Venice Commission also show, we don't have an explicit emergency clause, and obviously this is a thing that can be explained in light of the legacy of the ghost of the Weimar Republic. But my question for our authors is, do you think that a constitutional reform in this respect would be desirable today after the pandemic? And my final question is the following. In Italy, we are also witnessing a debate about asymmetrical regionalism. This has been also mentioned by Jens. Now, many of the scholarly and political views we see seem quite polarizing. Some scholars and some politicians seem to argue that asymmetry as such is a bad thing. They seem to suggest using a very trendy concept that perhaps the new version of Article 116 is a form of unconstitutional constitutional amendment. What do you think about that? I'm quite skeptical. I think that asymmetry is a very well-known instrument in comparative law, and I think that sometimes constitutional law scholars are biased. But I'm curious to know what you think about that. Do you think that we can say that this Article 116 is a form of unconstitutional constitutional amendment or not, and why? Thanks so much once again, and I will enjoy the book and the presentation. Thanks so much.
Thank you, Giuseppe. There is one question in the chat from a colleague from Chile, Esteban Smulevich. Esteban addresses the role of the state in the economy and social rights, and whether or not, in your opinion, the key provisions in the Constitution can still serve as an inspiration to other countries like they were when enacted. I have a question on my side. There's a point which Jens Woelk has also highlighted. In chapter 1, there is a strong emphasis on the role of the political parties to understand the Italian constitutional order. There is a reference to Pietro Scoppola, so the political parties actually predated the reconstruction of the state, the drafting of the constitution, and so on. So the question is, perhaps it's something that is underlying the paragraphs. What happens when the party system not only changes, but also sort of flounders? There is a paragraph whose title is a republic with a deinstitutionalized party system. What is the relevance? What are the implications of this reality to which we are confronted? We have to deal in the daily life today, when thinking of how our institutions works, how they should work, and so on. Thank you. Other point. If there are no other questions for the time being, I think that the authors may start answering. Who goes first?
Maybe Marta, if you would like, I pick some small issues, and then you take all the big ones.
Thank you.
If you don't mind. No, just maybe starting from the last one and going backwards. Yes, that's the point that Giacomo raised was absolutely crucial, and I strongly think the political parties were foundational for the Italian Republic. They played a foundational role. They are still playing a role which is not anymore foundational. Of course, because the parties changed dramatically in 1992. And this was indeed one point we wanted to stress even more, the change that happened in 1992. It's still in the book, but in the many versions of the book, it was even more crucial originally, this turning point. And it's true that they are still there. Political parties exist, but they are, I use some terminology taken from political scientists, deinstitutionalized, means that there is electoral volatility, and also that the party, there is a big mobility in changing parliamentary groups within parliament, and all signs of the fact that parties are not so fundamental and not playing the same role they were playing before. This was and still is, I would say, a big factor of stress for the Italian constitution and Italian institutions more in general. So you can read also the question about many issues that were raised by the two discussants also regarding constitutional reforms in this under this light. So the Italian constitution needs to be updated, or the institutions need to be reformed. Why? One of the most plausible answers, if you want to answer in a positive way, is because you don't have anymore the political parties ensuring a certain kind of functioning of the system as it was at the beginning. Of course, it's not a reply is an easy answer, so not, but I would say that this is the most plausible answer for those who support a constitutional reform of the in Italy. Maybe rather quickly on the question on the chat that was raised regarding the role of state and in the economy, if the Italian constitution might be considered still inspirational. I would say yes, but it is maybe the field in which you find that the influence of the European Union has been more important. So I don't think you can read anymore the Italian constitution regarding the relationship between the state and the economy as it was in the beginning. You need to insert all the influence that derive from the European Union and the treaties. And in this way, I think it's a system that has something to say, something to tell, but not taken as such. At least this is my view on this. Giuseppe raised a lot of issues, and I want to say much because Marta, I'm sure, is going to say something more important than what I could add. Maybe just about the terminological challenges. Of course, there are some that can be rather, let's say, you can decide for one or for the other. Court of Accounts or Court of Auditors, for instance. Corte dei Conti could be both, and so we opted for one instead of the other. It's okay. In other cases, we decide to stick to the translation that was more literal, if possible. So, for instance, you see decree laws, but there are no decrees. Why not? But or legitimate interest and subjective rights, which is always a challenge for those who among us who teach in English. It's really a challenge to explain to a non-Italian audience such concepts, but it's something that must be done. And also, so there are several cases on this, and I'm not going too much into it. But maybe one example can be quoted, and this is the one in which we insisted. We had many language revisions and discussion with the editor. So it's abrogative referendum. Many said, okay, this word does not exist. But how can you describe it? If someone, even today, managed to find a good translation, good alternative to abrogative referendum, please propose it, because I would be very happy to follow and to. But I think there was no other way. Once explained that the aim and the meaning, abrogative means to repeal a piece of legislation. But what other names can you use for expressing this concept? And of course, there are many, there are several of these cases, but this is, if you want, most interesting. And another fact that can be raised is the fact that we don't have a very reliable translation of the Italian Constitution into English. The ones we used were never fully satisfying. This means that sometimes in translating the text, we did some slight changes because we were not fully satisfied by the text we found in the Quirinale or Senato or Camera or Corte Costituzionale or so on. So maybe this can be a challenge and to be taken by the new scholarship asked to teach in English about the Italian system. The two discussants maybe the raised very, very important questions, and Marta will deal more better than me. I want to thank them really a lot for what they said. The readings have been different and also very stimulating for both of them have taken very important issues and some ambiguities also that exist and some choices that can be, of course, discussed and criticized. Maybe just one word in very general in the next stop on the regionalism in Italy, because we, in federalism, if you want, we decided after also this rather long discussion to opt for the formula Republic of Autonomies, which is the one to which we open chapter 7. And also this quotation of the decision of the Constitutional Court of 2007 at the end of the chapter is taught in order to reinforce, to strengthen this choice of Republic of Autonomies. We know that we are forcing a lot the term autonomy, which is not that common, and we know that the solution is not fully satisfying, I would say. But we have to, this was the case in which, in my opinion at least, the text of the Constitution and the context are very far away, the one from the other in Italy. Because if we stick to the text of the Constitution, we are not that far from a federal state, from a federal system, let's say. If we stick to the reality of the system and to the context, I would say that we are rather far away. If we say that we are a federal system, it's also almost a mistake, I would say. So this is really maybe the part of the Constitution in which I found more problems in reconciling text and context. And so your comments were particularly useful, I think, in this regards. So thanks a lot, and sorry for answering very partially to all the questions you raised, but thanks a lot.
Thank you.
Shall I?
Please.
Thank you. Thank you so much, first of all, to the discussants, because the remarks were really encouraging, first of all, and also insightful with a number of remarks that shall be noted for future editions, starting from the remark made by Jans when he said why the fundamental rights at the very end. And in fact, there is no reason for that. I mean, there is no reason. I don't remember that we were requested to do that. And also, it's the opposite, very strange, because in the text of the Constitution, they were put on purpose before the structure of powers, because the idea was to stress that the person, the human being, is at the center, and also the architecture of the institutional powers should be in a way designed in order to preserve the centrality of the human person. So in fact, this is something that we should reconsider. And in fact, it's something that captures a trait which is really typical of the Italian Constitution, as has been said, with a strong emphasis on safeguards, limiting powers, balancing guarantees and all the rest, and weaker on the side of designing strong powers for the reasons that we mentioned before. I would like to say just one couple of things, because there were so many interesting issues. One is about regions and the other about the Constitutional Court. But let me first reply to Giuseppe when he said what are the most difficult challenges in translation, and there are some of them. It is true that in many cases we have written this book in a period of time where comparison, global constitutionalism has provided us with a rich vocabulary in order to understand, and also not only vocabularies, but also a mindset that prepare us, scholars of the 21st century, to drop some precision in the translation in order to offer an equivalent, in order to understand and to make our constitution comparable to other constitutions. For example, sometimes we speak about constitutional court, even today in the newspaper speaking about Brazil, even if we know very that it is a Supreme Court, but we understand that we are referring to a high-level court that is also performing judicial review of legislation. So in many cases, I think that writing this book in this moment, it's much easier than it would have been, I don't know, 2 decades ago or something like that, because we were too much jealous of the legal precision of some institutes and less ready to go with the, let's say, similar words which does not capture exactly. But indeed, there are some concepts, some ideas. And I think that this is very subjective, very different from one person to another, for which we feel that we have been forced to translate in a bad way. For example, well, legitimate interest is not transferable to any other language, because it's something that is so difficult also to explain that it's almost impossible to explain what is the difference between a subjective right and legitimate interest. But also, I'm not satisfied with réserve de la loi, which is something that is readable in French, but less readable in English, or formazioni sociali. And if I'm not mistaken, in some cases, we left into bracket also the original Italian, because we didn't want we wanted to stress that the translation was a proxy. It was not exactly the right translation for the Italian concept, and some of the richness of the meaning were sacrificed in translation. But anyway, a couple of words about sovereignty and asymmetrical regionalism. Thank you also to Anna for mentioning this decision about the Constitutional Court saying, okay, we can have differentiated regions with a lot of power, more than other ordinary regions, but be quiet, there are some words, some qualities that are only for state, and one of these is sovereignty. This was provocative because it was not a very serious legislation, but it was important as a matter of principle, and it was relevant, this decision, when years later, and I was the rapporteur, I think, in that case, we had to confront with the request of the Veneto region to prompt in the framework of the revised constitution a process for asymmetrical regionalism to be implemented. So this debate, sovereign regions and asymmetrical regionalism, in a way, is the sign of the political debate. The 2007, it was still in the in the wave of this debate calling for independence of some regions. There was a call for autonomy in the sense of separation, independence from the state. It was the original position of the Liga. Then this debate has been completely exhausted, and it is no longer, even in the strongest wings of the Liga, there is no call for independence of some region. But the debate is very serious, and in my view, in the next years, with this new government, can become an issue of implementation of this Article 116, allowing for an asymmetrical regionalism on the model of the Spanish one. We have already some special regions, but Article 116 wants to go further and to have regionalism à la carte within a certain limit of issues and topics, but giving the possibility to some regions to go further than others. And this will be very, very tricky decision, because as Jans said, this differentiation should be implemented always keeping in mind that we are in a constitution that wanted to preserve the unity of the Italian territory, the Italian people, which is something always to be conquered, always to be attained, because different realities still divide social life, economic life in our country. On the Constitutional Court, I have to say that this book capture an image of a constitutional court in the last, let's say, 10 years, which was very active and very dynamic, very creative also, as you mentioned, the decision on euthanasia and end of life, trying to engaging with the parliament new forms of cooperation, a new instrument from the procedural point of view. And under this respect, I would say, Anna, that when you said that compared to your court, the Italian Constitutional Court encourages lower judges to resolve the problems on their own by means of interpretation, I would say that this is something that belongs to a previous stage of the case law of the Constitutional Court around the 90s, the mid-90s. In recent times, many scholars has remarked that the Constitutional Court is becoming more jealous, more centralizing in the decision of unconstitutionality, less inclined to leave too much room to the lower courts. And in part it is true, because during the 90s, in a way, the judges were requested to give evidence that they tried by means of interpretation to conform the legislation to the constitutional principle, lest the court could decide the inadmissibility, releasing the decision on the basis of procedural concerns. Now, this kind of request made to the lower courts is less present in the decision of the court. So when the case arrives to the bench of the Constitutional Court, in general, the courts tends to take it. If you consider, and in Pisa, they are the expert counting and looking at the data and the statistics. They are really very good at that. In general, in the recent time, the decision on procedural grounds are reduced compared to previous years. So that means that the courts tend to intervene on the merits. It is a more, let's say, proactive court under many respects. Well, there are so many other things, but I think that we can stop here for the moment. I don't know if there are some other questions, or if you wanted to us to reply on a specific question that we dropped or didn't consider. Maybe you can tell us. Thank you for the moment.
Thank you. Any questions, any replies? I don't know if Jens Woelk and Anna Gamper want to rejoin. Jens, possibly? I don't know.
No, I think a lot of very interesting things have been said. I also find very important what has been said regarding the terminological issue, because this is always a problem with comparison, but I think there is not much to add. The solution, the kind of how to say, obliged solution to sometimes use the brackets and put in the original term. I think this is the best one, also because this, or the best one, this is the unavoidable one, let's say, in order to flag that there is an issue which is not so easily translatable and which is so culturally specific that you have to pay special attention to this issue, and I think this all of us who are translating texts or who are reading in different languages and try to explain in another language have already felt the need to do so, because otherwise there is no real solution. Law is culture in the end, and or linked to culture, at least product of culture. So I think this was maybe, then of course with the regionalism issue there is a lot to say, and we had a conference in Trento last March where we also tried to kind of summarize the evolution and to look a bit into the future. For me, the great puzzle is always what I already said in my first part. The puzzle is always, what is this regionalism for in the long term? What's the strategy? But maybe this is a very German question, and yeah, I leave it here. Thank you.
Thanks indeed. So, Anna.
Just two small remarks. Firstly, to what Marta Cartabia said about the change in the attitude of the Constitutional Court towards the admission of cases. I think that's very commendable, because even though the caseload, of course, increases in that sense, but I think it's a problem if lower courts tend to use the consistency method too much and do not submit to the Constitutional Court. That was the claim I made, because I knew the Austrian situation, that courts not specialized on constitutional questions decide case of doubts about the constitutionality of a law. And I think that's problematic, because the statutes might be unconstitutional and they do not get to the Constitutional Court, and the court has no chance of repealing them. That was the point I tried to make. And just one word to what Nicola Lupo said about the Italian constitution being almost federal with regard to the text, but not with regard to the context. This is something on which I read much in the Italian literature. I think one point is the Italian Senate, because perfect bicameralism is not understood as a kind of federal second chamber, and the Senate doesn't work as a really full-fledged federal second chamber. And I think the second element that is absent is the constitutional autonomy of the regions, because the statutes of the specialized regions are central constitutional laws, And the statutes of the ordinary regions would be something, you know, beginning of what we could call a constitution of a region, but they may only regulate some matters. However, I'm not sure whether when we apply these criteria, whether we could speak of many federal systems across the globe, because I think these elements are always, nearly always missing. For example, in Austria. So we do have a so-called federal second chamber, but it does not at all work to the interest of our 9 Länder, of our 9 regions. So the same problem here. And again, we could discuss what is constitutional autonomy of the component units. So you find some federal systems where they have wider autonomy, others without, or just a little bit. So if we apply these 2 criteria, I think we would have to declassify many federal states as being federal, at least when it comes to what you call the context. Thank you.
Well, thank you. I think we are approaching the end of our webinar. I would like to thank all of you, the authors, of course, for the participation, for the generous participation, our 2 discussants, and all the colleagues and friends in the audience. I think the discussion has been very useful to raise a number of issues related to what teaching your own constitutional system in another language entails, on the implications of the growing international community of constitutional law scholars, and what the emergence of such community means for our work, for our research, and a number of unfinished business, unresolved knots, emerging problems that characterize our constitutional system and make it so interesting and so the promising ground for further research. So thanks indeed to all of you, and see you soon for the next STAUS webinar. Goodbye.